So we have about 20 minutes for questions, and before we head to the reception. And I have, if the room goes absolutely silent, I have some questions that I can ask, but I'm really hoping that I don't have to do that. I mean, as I said, you're the reason that we put this on. The people who organize these programs, including the justices, they really want to know what you think about all this. We want to get your impressions, we want to get your reactions, we want to get your questions. So don't be shy at all. Please, if you have any question or you want to comment, raise your hand. A microphone is going to go around. Yep, right there. So please don't be shy. If anything at all you want to say or ask, raise your hand. Feel free to ask it. There's no stupid question. Actually, I'm going to start real quick with one question for the attorneys, just to kick things off. I'd ask each attorney to just kind of, if you wouldn't mind introducing yourselves, maybe say a little bit about your practice, and if you have any kind of first impressions about the argument, you could feel free to say that as well.
Good morning. My name's Phil Ellison. I'm an attorney from Saginaw. I did about 1 million years of school to become a lawyer, which any of you guys are thinking about becoming a lawyer, you got a little ways to go. But let me tell you, when I decided to become a lawyer, I was 17 years old, I was in high school, and I got a bullshit parking ticket in Saginaw, all right? Now, I'll say that because now that's the PG-13 word I would use to describe that parking ticket. I called the City of Saginaw Parking Bureau over and over and over and over and over again and could not get them to budge, could not get them to move. And at that time, I had joined the mock trial team at the high school, and our coach was a local attorney. And of course, we came to the session, the practice session, whatever, and I was complaining about this ticket, and he said, well, don't worry, I'll take care of it. One phone call from him, problem was solved. And I remember thinking at that time, like that's pretty powerful that a lawyer has that kind of influence in the system, and that's when I decided to become an attorney. And of course, then a number of years of school later, a number of work later, now I'm an attorney here today. So that's a parking ticket that was, and to this day, is not my parking ticket, is the reason I became an attorney.
And you've now realized we don't have that much power and influence. My name's Alex Bomarito. I currently practice in Freeland, Michigan, my hometown. It's kind of odd that me and Phil are here, and we literally probably are 15 miles apart or less. We've had plenty of cases together in the past. My practice is general civil litigation, primarily real estate, construction, some personal injury, and then I guess I specialize a little bit in appeals because there are several attorneys that don't want to do appellate work. I know Phil takes on cases from attorneys who don't want to deal with it. I didn't decide to become a lawyer until much later, but I've done a little bit of everything. I started out in intellectual property, which is patents and trademarks and copyrights, and then decided I wanted to come back to Michigan. And unless you want to live in large metropolitan areas such as Detroit or Grand Rapids or a little bit in Lansing, there's not much of that work to go around. So coming back to the Saginaw area, I focused in on litigation, which I also did in the intellectual property world. So you can go in as many different directions in the law as you might want to. You don't need to specialize, like a doctor. They become a surgeon or they become an oncologist or whatever specialty it might be. You can take your background, go to law school, and then kind of direct your own course. Sometimes that course is not necessarily in a straight line, but you can kind of go where you want to go with it, depending on what you want to do with your life. So.
Thank you very much. Do we have questions?
This is for the Maniaki, sorry about that. Okay, so this is for the Maniaki side. I had a question. So, if the appeasement permits the use of like kayaks and small watercrafts being put into the water, and like the guy said he didn't have an issue with that.
Can you just wave wherever you are? Okay, all right, cool, all right, fire away.
And so I read that in the debriefing part, there's a full-scale like boat launch less than half a mile away. Why would we need to put another one in right there when it would just be simpler, just go down the road a little bit?
Well, that's the question I get quite a bit when I deal with these private easement cases. So to kind of latch on, I kind of went with my ticket story. So my area that I do a lot of is property rights. So here's to answer your question. I mean, real basic is that it's not a secret. The state of Michigan doesn't have a lot of money in the government anymore. What happens if they close down that public launch down the street? Then my client, if he doesn't protect his right to have private access, which he negotiated for, if that public easement goes away, he has no water access anymore. And I'll tell you, the very frank matter is that when your property had water access and it no longer has water access, the value of your property drops by 1/3. So my client's not only protecting his rights that he negotiated, but he's protecting against future problems that aren't even there yet, but could come up. And he wants to make sure his rights are protected. And I don't know if you guys, I don't want to point him out here, but I told him I wasn't going to point him out and bring him up on stage, but he's here today. Jeff Maniaci is here today. And it's very important to him to be able to protect these rights so that not only when he goes to sell his property, or if he wants to give his property to family or friends or whatever else, that those rights go forward. And as you heard during oral argument, not only, and I give Jeff a lot of credit for this, not only as part of the settlement, he could have negotiated just for his own rights, but he didn't. He negotiated and received the rights for everybody in that neighborhood. So that's to answer your question is we as lawyers, we try to best position ourselves for our clients for not only to solve the problem that's at hand, but the 17 other things we never thought of coming on down the road.
All right. Thank you very much.
Yep. We don't clap after every one of those suckers. My God.
So you mentioned earlier that he has another land that has water access. If the park does close down with the boat launch, couldn't he just modify that to get water access?
So you can see, so there's a lawyer's trick we use, right? Justice Bernstein wanted me to admit that my client has a back way into the water. Golly shucks, I just don't know, right? And that's a neat, and I say it's a trick. I don't know that answer, but frankly, I don't think it's really relevant. Whether if you have two access rights, doesn't mean that just because you have two means you got to give up the first one. So the answer, could he? Theoretically, yes, but at the same token is that he doesn't have to give that up, and frankly, he shouldn't have to give that up. You know, that's like saying if you are fortunate you have two iPhones, you got the new what's the new one, 11 now? You have the new 11 and you had the 10 that you have to give your 10 to somebody else just because someone else doesn't have one. They can buy their own phone in that respect.
Hello, you kept mentioning something called Black Hawk. What is that?
Take that one. Blackhawk was a 2003 Supreme Court case that dealt with an easement, and in that case, a developer wanted to. There was an easement that was given to the municipality by a property owner to improve the road, and the developer wanted to kind of bootstrap onto that and build a building and have parking lots and service drives and. The property owner objected and say, I gave my easement to the village, or I think it was the village of Dexter, and to improve this specific road, I didn't give him an easement to allow this guy to develop this property that's adjacent to mine, but then essentially utilize my property as an easement area to benefit that person's adjacent parcel. So we were just citing precedent is what we were doing. And Blackhawk, it's kind of interesting because Justice Markman was on the panel, and I think Justice Kavanaugh's dad wrote the opinion. So.
This isn't really a question, but a coincidence. My name is Philip, and I'm from Saginaw, so.
Hi, Philip from Saginaw. Four questions. 1L or 2L, Philip?
But he's really from Hemlock, not Saginaw. So.
Hello. So you had stated that there had been affecting other neighbors in the matter. Have there been any other formal complaints about the case coming from other people who live in the neighborhood?
Largely no, and I think a lot of it is because Jeff, through my office, has been kind of running the lead on this. No one else has really stepped up because they're going to wait to see what comes out of this kind of line of cases right now. Because if the justices conclude that my client doesn't have the right to regrade the property, we still have an easement. The easement doesn't go away, and that's one thing I want you guys to take away from this is just because they don't agree that the grading is there doesn't mean the easement's there or is gone. They still have certain rights, and the question will be is how much rights do they actually have in that respect? And we may have to do it a different way. The trial judge, interestingly, which nowhere in the easement does it use the word crane or large piece of equipment, but the trial judge said, well, you could use a large piece of equipment to crane the boats into the water themselves. Well, isn't it just as easy or even maybe easier and more reasonable to be able to alter the slope going forward? Maybe. At least that's our position. But the important part is that the neighbors are simply, I think, just kind of waiting to see what comes out of this because Jeff is the one that got it for him. Now we're fighting about what the scope of that actually means.
To clarify the property, our second property, we cannot make a boat ramp because the way that properties are divided, we barely have a driveway that goes to the property. We have a driveway in front and the back of the house.
So this is Mrs. Maniaci.
We don't have access to put a boat ramp in.
So, and one of the things too, guys, I'll add to that with that comment, as lawyers, a lot of times we are representing folks who, I mean, we forget sometimes while we're up here, and this is kind of a lot of pomp and circumstance with this, we represent real people. Real people with real problems that are trying to find resolution, and the way we find resolution is we use the law and how the law applies to certain circumstances. And so a lot of times people forget that behind all of this robes and heary, there's real people that are affected by how these cases are the outcome of them provide.
Hi. So I guess why should the easement owner be entitled to deciding what is damage or beneficial to someone else's property? I mean, even if they have the easement, it still affects their property's use as a whole. So why should the easement owner be the one who gets to decide that?
Because I'm right.
That's your official answer?
So it's a fair question. I mean, it's a fair question in the fact that is what I believe the law of Michigan provides for. Now, the law could change, right? The legislature could enact a law that says the landowner, the non-easement holder landowner, has more rights than the property owner or the easement holder. And the reason why is that these are just the rules that we have set up for ourselves as a state to govern the way that we interact between neighbors, where one party has the right to use but does not own the rights of another. So, for example, each of you, I'm guessing all of you live in the Traverse City area, every one of your houses has an easement on it. Out in front of your house, you don't own to the edge of the road. Your parents actually own to the middle of the road itself. And the middle of the road is where the property line actually is. And so actually there is a public easement that runs across these properties. So what happens is that you can't build a shed on the middle of Division Street if you own property on Division Street. It's because you've agreed to limit yourself as the property owner to let someone else use it. Motorist. Same sort of thing here. So should a property owner along Division Street or Front Street say, well, you know what, I own to the center of the street. I don't really like those cars driving by from 9 p.m. to 6 a.m., so I'm going to put a giant boulder in the middle of the road each night so that you can't use the street anymore. Well, we'd say no go, right? Probably get arrested, right? But in that instance, the easement holder, the public, has rights that are greater and more respected than the person who owns the land underneath of it. So it's the same parallel. And of course, we're going to argue as lawyers. We argue for our client's position. And as much as I want to say, and I believe that as Justice Markman was asking about, where do you get the ability to say that the rights are paramount? That comes from law. Now, these justices have the ability to change the law or to be able to reinterpret the law or adjust. And that's what Alex, of course, is going to try to advocate for his clients or say that that particular law shouldn't apply in these particular circumstances. And so that's just, I mean, if we don't like it, this is what court cases change, and this is what, otherwise write your legislator that way.
All right, so what do you do when you're asked a question that you can't answer? Let's hear it.
You take a breath and try to come up with the best answer you can. I mean, you can't not answer the question, or you're going to leave a justice or a judge not favorable in your position.
Thank you. So my question is twofold. So first of all, wondering what changed in either the land or the Maniachi's watercraft situation to make them want to change the land? And then also, since the condition of Parcel B has been unable to launch their boat, where have they been launching their boat?
So the land that's, I don't know if you guys, how much of the papers they gave you beforehand. Right before this court case started originally, that land sloped to the water's edge. And that's the place where folks would launch boats from there for many, many years. The Deeroffs, right before the court case started, brought in truckloads and truckloads of sand and dirt and built that area up. I could hear it kind of in the back room, but you guys said they showed you a picture of the area. Is that yes? You guys are just little figures. I can't see with the light, so that's why you yell back. But so they brought in all this truck material and all the sand and dirt and gravel and built it up to something it traditionally wasn't. So the idea is that as of right now, it's still in the position where it's got that large drop off at, but yet it's the Deeroffs, I think, are the ones that unfortunately are the ones that caused a lot of the problems here by changing the traditional way that property had been utilized and benefited for everybody in the community. I think that answers your question.
All right, so I'm going to kind of continue this question over here about the lay of the land. So, like, what you guys talk about, how it wasn't natural. They kind of built it all up, and it's just a giant slope that kind of goes down, kind of like a semi-U shape. Like, I got a cabin up in Mullet, and we all have like the easements that all share this one waterfront. We got 3 houses on one side, 3 houses on the other side, and like a giant U driveway. Yep. And I understand what you guys are talking about when you guys are talking about like the kind of like the half U. What I'm kind of wondering is that since like over the years that's been there, has it eroded a little bit? So is it kind of now uneven instead of just a straight U, or is it like kind of rock wall there? Or?
So traditionally, until the case started, it was very level. I mean, it leveled off where you could back a boat into the water itself. And then when the Deeroffs built that area up, they put in sand, and then they put in a lot of rocks and things of that nature. So yes, in some respect, the shoreline has eroded a little bit just with rain and water, but still, the picture you saw is what's there today. Literally, if you back a trailer up to the edge and you drop off that ledge, your trailer is going to go like this, and you're going to be stuck. And interestingly, and one of the things that we were talking here in oral argument is what were some of the concessions? Because Alex comes into the case, his clients bought the property after the consent judgment was entered. So he's kind of stuck with what happened beforehand. And during that hearing, the lawyers for the Deeroffs, a guy named Bill Carey, conceded that you can't back the trailer. As it stands right now, you can't back the trailer into the water. And as a result of that, that's where one of my arguments come back and say, but you agreed to let us do this. That's specifically what you agreed. And of course, I'm going to argue that his clients are stuck by that agreement because they're the subsequent buyers. So yes, it's eroded, but it hasn't eroded enough to be able to put a boat trailer down there at all.
We have time for one more question.
How much money do you guys got in your pockets out here today? So, I mean, that's something, $20. That was one of the questions where, at the time that the morning of trial on this, there was the question of how do we settle the case and get the rights that we thought we were getting, or do we take the risk with the trial court judge? And my client opted at the time to take the risk with go get reduce what we thought was reducing the risk by taking the agreement. And so they would have the ability to bring in and themselves do it themselves. But however, there could be, the neighborhood itself could come together because the neighbors got more rights out of the outcome of this case than just Jeff and Judy that way. So we haven't got to that question yet, simply because we haven't been able to agree, can they even do it in the first place? So stay tuned.
So that's all the time we have for on the questions. When we go to the reception, if you have more questions, if you didn't get a chance or you're just a little shy, they'll be at the reception. You can ask them. You can go ahead and go straight to the justices. They love to hear from students. So thank you, everyone, for coming, and I will see you at the reception.